3 weeks ago, the party carrying Peter Obi and Rabiu Kwankwaso into the 2027 election didn't legally exist. A federal high court judge in Lokoja set aside the very ruling that had brought the Nigeria Democratic Congress into being. And yet, this week, INEC quietly did something that seems to contradict all of that. It opened its candidate portal to the party, and Peter Obi's name is now sitting inside it as a registered presidential candidate. So, which is it? Is the NDC legally alive or legally erased? The honest answer is both at the same time, depending on which court order you're standing on. And the gap between those two realities is where Nigeria's opposition coalition is currently living. Nobody, not INEC, not the party's own lawyers, not the judge who wrote the order, can tell you with certainty what happens if that contradiction isn't resolved before ballots are printed. Stick with me, because by the end of this, you will understand exactly how a country can have a presidential candidate on a portal and no functioning party behind him, and why that's not a glitch. It might be the point. Before we go any further, if you are new to this channel, welcome. Naija Insight Desk exists for one reason: to give you the kind of analysis that goes beyond the headlines and the noise. Subscribe now, because this conversation is about to get deeper. Let's establish exactly what happened, because the sequence matters more than the headlines suggest. In December 2025, the Federal High Court ordered INEC to register the NDC after the party argued its constitutional right to freedom of association had been denied. INEC complied. From that point, the NDC built out a real political operation: ward congresses, state and national conventions, primaries conducted on INEC's own timetable, and by-election candidates fielded in Nasarawa and Enugu. This wasn't a paper party, it functioned. Then, on Friday, June 26th, that foundation was pulled out from under it. Justice Issa Dashen, the same judge who issued the original registration order, set that order aside, not because the NDC did anything wrong, but on a procedural ground. The Peace Movement Party, a group claiming ownership of the very logo the NDC had registered with, argued it was never given a chance to be heard in that case. The judge agreed, ruling the earlier judgment breached the constitutional principle of fair hearing and ordered everyone back to the position they were in before December 10th. Here's the part that matters for timing. This didn't come out of nowhere. It landed just as Peter Obi and Rabiu Kwankwaso had cemented themselves as the party's presidential and vice presidential ticket, and just as the NDC was becoming the most credible single vehicle for a united opposition front. Whether that timing is coincidence or strategy is a question we'll come back to, but the practical effect was immediate and severe. Every action INEC had taken under the vacated judgment, including the party's very existence on the register, was now in question. The NDC didn't sit still. Within days, the party filed a Court of Appeal challenge alongside a motion for stay of execution. And in a move that's easy to miss in the noise, INEC granted the party portal access anyway, and NDC national leader Seriake Dixon confirmed both his and Peter Obi's names had already been uploaded as candidates, with Kwankwaso's expected imminently. So, as of this week, we have a court order saying the party's registration doesn't exist and an electoral commission behaving administratively as though it does. That contradiction is the story. To understand how we got here, you need to understand three institutions and where their authority actually starts and stops: the Federal High Court, INEC, and quietly in the background, the Court of Appeal. Start with the judiciary. Nigerian courts generally cannot revisit their own final judgments, a legal principle called functus officio. Once a judge rules, that judge's job on that matter is done. Only a higher court can undo it. That's precisely the argument the NDC's leadership has made publicly. Their chairman insisted the same court cannot nullify its own judgment. But Justice Issa Dashen's order rests on a recognized exception to that rule. Courts can set aside their own judgments when those judgments were obtained through a denial of fair hearing to an affected party, or through fraud or suppression of material facts. Justice Dashen's ruling explicitly invoked that exception, finding the Peace Movement Party should have been joined and wasn't. Whether that exception was applied correctly is exactly what the Court of Appeal now has to decide, and that's an important distinction to hold on to. This is not a ruling on whether the NDC deserves to exist as a party. The substantive question, is the NDC validly registered, has not been decided. What's been decided is a narrower procedural question. Was the earlier process fair to everyone with a stake in it? Multiple legal observers have made this same point. This is being treated as a significant procedural setback, not a final determination of the NDC's legal status. Then there is INEC, and this is where the ambiguity gets structurally interesting. INEC's public position has been cautious. The Commission said it was waiting for the certified true copy of the judgment before acting further. But in practice, it has continued to treat the NDC as an operating entity, opening the candidate portal to it even after the registration order was vacated. That's not INEC defying the court, it's INEC operating in the gap the court order created, a gap where the practical machinery of the 2027 election timetable can't simply pause while the legal question resolves itself in an appellate court that hasn't set a hearing date. INEC has effectively been forced to run two parallel processes, one procedural and legal, one administrative and electoral, and they are not currently synchronized. That gap is where the real power sits right now. Whoever benefits from prolonged ambiguity has no incentive to rush the Court of Appeal, and whoever needs certainty, the NDC, its candidates and its voters, is the party with the least control over the calendar.
Now to the question every viewer actually wants answered. Who benefits from this and who's exposed? Start with what a prolonged legal cloud does to a coalition party specifically. The NDC isn't a decades-old institution with entrenched regional structures the way the PDP or APC are. It is functionally a vehicle, built rapidly to house Obi, Kwankwaso and Seriake Dixon's political networks after their departures from the ADC and Labour Party. Vehicles like that run on momentum and credibility. A legal cloud doesn't just threaten the party's existence on paper, it threatens the psychological confidence of candidates who joined betting on the platform's stability. That's precisely why Dixon felt compelled to publicly address reports that some candidates were considering abandoning the party altogether, because uncertainty this close to primaries and portal deadlines creates real defection risk, independent of how the appeal ultimately resolves. Now, if what you just heard challenged what you thought you knew, drop it in the comments. I want to hear your read on this before we get to the part that reframes everything. Who gains? The most direct beneficiary of NDC instability is the ruling APC, which doesn't need to defeat a unified opposition if that opposition spends the run-up to 2027 fighting legal battles instead of building ground operations. But it's worth still manning the counter view here too. A political analyst quoted in this cycle's coverage argued that Nigeria's fractured opposition, not judicial interference, is the more fundamental reason court rulings like this one land so hard. His point, a united opposition could contest and absorb a ruling like this one. A divided one experiences it as an existential threat. That's a structural critique of the opposition itself, not just of the judiciary, and it deserves weight. There's also a quieter beneficiary worth naming, the Peace Movement Party. The group's logo dispute triggered this entire reversal. Regardless of its merits, it has, in a single filing, forced the most prominent opposition presidential ticket in the country into a legal holding pattern. That's disproportionate leverage for a party most Nigerians had never heard of before this case. And who's conspicuously not saying much? Watch the ADC in this cycle. The NDC absorbed Obi and Kwankwaso in large part because of unresolved leadership disputes inside the ADC, disputes that went all the way to the Supreme Court, which recognized one faction but sent the underlying case back to the Federal High Court for further proceedings. If the NDC's own legal status now becomes similarly contested, the ADC's silence stops looking like irrelevance and starts looking like patience, a bet that Obi and Kwankwaso may eventually need a landing spot again. Step back from the legal chess match and ask what this means for the country beyond the candidates themselves. For federal-state power balance, this case is a live demonstration of how much control INEC's administrative discretion has over who effectively gets to compete, regardless of what courts decide on paper. INEC choosing to open portal access to a party under active legal challenge is itself a political act, whether or not it's meant as one. For ordinary Nigerians, the people this channel exists to center, not just the political class, the effect is corrosive in a specific way. It teaches voters that party registration, candidate eligibility, and even ballot access can be rewritten by a single lawsuit months after voters believed those questions were settled. That doesn't just affect NDC supporters. It tells every Nigerian that participation in the process can be undone retroactively, which is exactly the kind of uncertainty that breeds disengagement rather than turnout. There's also a regional dimension worth being precise about, because this channel doesn't traffic in vague claims about ethnic tension. The NDC's ticket pairs a southeastern figure in Obi with a northern figure in Kwankwaso, one of the more deliberate attempts at a cross-regional coalition in this cycle. A collapse of that platform doesn't just remove two names from a ballot, it removes one of the few structures actively working against the perception that Nigerian politics defaults to regional blocs backing regional candidates. For the diaspora audience watching this in London, in the US, in Canada, in South Africa, here's what actually travels beyond Nigeria for this story. Not the logo dispute itself, which is a domestic procedural matter, but the pattern it fits. International observers of Nigerian democracy have increasingly flagged judicial unpredictability, courts reversing their prior rulings, parallel and sometimes contradictory judgments on the same electoral questions as a credibility risk heading into 2027, separate from whoever wins or loses any individual case. That matters for how Nigeria is perceived by multilateral bodies and foreign governments assessing electoral credibility ahead of 2027, not because any single ruling determines the outcome, but because a pattern of contested, reversible judicial decisions is precisely the kind of signal that invites external scrutiny of the process itself, independent of who benefits from any one ruling.
Let's steelman the other side properly, because a lot of the commentary on this story, including from opposition-aligned voices, has overstated what actually happened. The strongest version of the "this is a legitimate legal process" argument goes like this. Courts exist precisely to correct procedural violations, even inconvenient ones. If the Peace Movement Party genuinely wasn't heard on a matter directly affecting its interests, then setting the judgment aside isn't judicial overreach. It's the system working as designed, protecting the fair hearing rights of a third party who had no other venue to raise the issue. Under that reading, the NDC's misfortune is a byproduct of its own case being built on a contested logo, not evidence of political targeting. Now, the most common misconception circulating in social media commentary is the claim that the NDC has been deregistered. That's not accurate, and it's worth being precise here. The party's own national chairman has explicitly rejected that framing, and the ruling itself did not order deregistration. What happened is narrower. A prior judgment ordering registration was set aside on procedural grounds, with the substantive question of registration still pending a fresh hearing. Calling that deregistration overstates the legal reality and, frankly, plays into the same sensationalism this channel exists to cut through. The nuance being lost in the noise is this. This is simultaneously a genuine legal question about a contested party logo and a genuine political vulnerability for an opposition coalition that arrived comparatively late and without the deep institutional roots of Nigeria's older parties. Both things are true, neither cancels each other out. What this means for Nigeria's democratic trajectory is straightforward. Institutional gaps like the one between this court order and INEC's portal access will keep getting tested by whoever has the resources and motivation to litigate them, and ordinary voters will keep absorbing the uncertainty that creates, regardless of which side of the aisle is doing the litigating. So, what happens next? 3 moves to watch. First, the Court of Appeal's handling of the stay of execution. If it grants the stay quickly, INEC's current administrative treatment of the NDC, portal access, candidate uploads, gets legal cover, and this becomes a manageable footnote rather than an existential threat. If the appellate court is slow or declines the stay, the contradiction between the legal and administrative tracks gets worse, not better, the closer we get to primary and nomination deadlines. Second, Watch whether the Peace Movement Party pushes for a fresh hearing on an accelerated timeline or lets the matter sit. A party with disproportionate leverage sometimes has more to gain from delay than resolution. Third, watch the NDC's own candidates. Dixon's public reassurances exist because there's already reported concern about candidates considering other platforms. If that trickles from rumor into actual defections, particularly at governorship or National Assembly level, that tells you more about the ticket's real durability than any court filing will. The 12-month outlook. If the Court of Appeal resolves this by year-end, this becomes a resolved legal footnote in the NDC's origin story. The 3-year outlook is more structurally interesting. Regardless of how this specific case resolves, it will likely accelerate calls for INEC and the National Assembly to close the procedural gaps that make this kind of last-minute reversal possible in future cycles, gaps that don't discriminate by party. So, is the NDC legally alive or legally erased? The honest answer still is neither, cleanly. It exists administratively in INEC's portal with Peter Obi's name already uploaded. It does not exist with full legal certainty because the underlying registration question remains unresolved pending the Court of Appeal. Both realities are currently true, and Nigeria's electoral calendar isn't going to wait patiently for the courts to pick one. That is not a prediction dressed in certainty. It's where the evidence actually sits today. What happens next depends less on any single dramatic ruling than on how quickly an overburdened appellate process can resolve a question that Nigeria's electoral timetable has already functionally moved past. If this analysis gave you clarity, not agreement, clarity, share it with one person who needs to understand what is actually happening. Like, subscribe, and I will see you in the next one.